Meeting is being recorded.
Hi, happy Wednesday. My name's Colleen Masse. I'm an attorney at Czepiga, Daly, Pope and Perri. Today I'm going to be talking about estate planning. If you have any questions, please pop them in the group chat. It's a small group, so I will try to answer as we go along. Even if there's something specific you were hoping to learn about today, if you want to pop that in the group chat too, that way I'll make sure not to miss it. So a little bit about our firm. We are a firm statewide, so we have 5 offices. We are 27 years old, and we do estate planning, elder law, disability planning. So we don't do any slip and fall cases. If you have questions about your parking ticket, I am not the person to ask. Don't pop that in the chat. I will not know the answer. But I'm happy to try to answer any other questions that might be in the scope. Just keep them general. I can't answer specific questions unless you're a client. So off we go. So we're going to talk about the basic estate planning documents today, and the basic estate planning documents that I think everyone should have in place are power of attorney, which we'll talk about first, a healthcare directive, and a last will and testament. Those are the 3 major documents. There are, of course, many other documents that are appropriate for some people to have, maybe not appropriate for others to have. Some of them include different kinds of trusts, right? Different kinds of appointments of property, different things like that. So we can talk about those as they may or may not be relevant. But the first thing we're going to talk about today is a power of attorney. That is a document I do suggest for all of my clients. And if you come in and you are my client and you tell me that you have a 19-year-old child, I will also suggest it for your 19-year-old child. So a power of attorney document does allow someone to make financial decisions and some legal decisions for you if you are unable to, or even if you just kind of don't want to. And the reason I say don't want to is because sometimes, during the COVID days when people were, especially people that had immune compromised situations, they may not have wanted to go to the bank. They may not have wanted to go to a real estate closing. So they would be able, they'd be competent to do that, but they didn't want to go out and expose themselves. And in those situations, you could send your agent under a power of attorney to do those things too. So it's an extensive document. Connecticut did update the power of attorney statute in 2017. So if you happen to have one and it is older than 2017, then you might want to have it looked at and make sure that it is going to be up to the current legal standards. A power of attorney allows someone to help with banking, um, manage assets, sign legal documents. I get a little nervous about the access safe deposit boxes on here because I don't want to give anyone a false sense of security. We do find accessing safe deposit box it's very difficult. Becomes a very difficult issue. So occasionally we'll have, someone that needs someone to go to a safe deposit box for them. And when they get to the bank won't accept a power of attorney. Or sometimes we'll have someone that passes away and their heirs will need access to the safe deposit box. That can be very difficult. So I'm just taking a moment here to give some warning and some, just raise the issue so that you're aware that safe deposit boxes can be difficult to contend with. If you have one, you want to make sure that you have other people listed on that and make sure that it's actually done, not just that you've requested it. But a power of attorney is something that as I mentioned, everyone should have it in place, and having that in place can make other things in the future easier. Because if you have your power of attorney in place and something happens in the future and you're incapacitated and something needs to be changed in your estate planning, your legal documents, your agent should be able to do that. And that allows for a lot of flexibility as things change in our lives. The reason that I suggest it for everyone, even young people, is because, first of all, we don't know what's going to happen if we could be in a car accident or something like that. And second of all, for convenience. So, for instance, when one of my sons was studying abroad and there was a changeover in the bank got bought by another bank, I was able to go and deal with his banking issues. And so a lot of times when kids are in that 18 to 22 year old time, they're used to their parents being able to help them. And this allows you to continue to help them throughout that. So I do suggest that everyone have this in place. I don't know if you would just kind of put in the chat if this is a document you do have in place. I'd be interested in knowing how many people have these as part of their documentation. A power of attorney can't do, I mean, they can do a lot, but they can't do everything. They can't change your will or invalidate it. They can't make decisions on your behalf after death. So what this means, and we will get calls about this. Hi, I'm my mother's power of attorney. She passed away and the bank won't accept it anymore. The bank is correct. You are only the person's agent under a power of attorney while the person is alive. Because it's essentially letting you step into their shoes. And they have to be living to be able to be doing these actions. So you are stepping into their shoes, you are acting on their behalf, and that stops upon their passing. So, the power of attorney is very powerful, but it does have some limits. You can't change the power of attorney to a different person. And you are also expected to act in the best interest of the principal. The principal is what we call the person who set up the power of attorney, the person who is probably my client. That's the principal, and you are expected under the power of attorney to act in their best interest. If you don't, you could be sued. There is liability for that as long as you are acting in their best interest, and as long as you are acting to the best of your knowledge, and you're not purposefully, stealing from them or anything like that. Then the agent, would not have any liability. So it's an important document. We do suggest that everyone have one in place, and that's regardless of age. So any questions about the power of attorney document or the changes that came into place in 2017? Okay. It does, it is a little bit complicated in the way it's set up. So you do want to make sure that you're getting good advice as to there are some spots to initial, some spots not to initial, all that stuff. So you want to make sure that you're getting good advice on that. You want to make sure it's executed properly, right? Witnessed and all of that, notarized, the whole thing. Typically, you don't need an original power of attorney when you're transacting unless you're doing something that needs to be recorded on the land records. So if I were my parents' agent and I was going to go to the lawyer's office and sign the deed on their behalf, at that point, the original power of attorney needs to go to the town hall. But otherwise, a copy should be accepted. So the next super important document is the healthcare directive. Again, this is another document that is effective during the person's life. So this allows someone to make healthcare decisions for you. It allows them to talk to your doctor, and it allows them to, to carry out your wishes when you're not able to. So this is a little bit different from a power of attorney, right? Because I said there might be times in my life where I just said, I don't want to go to the bank and I want my friend Joan to go to the bank for me. But when it's a healthcare representative, if I'm able to make my own healthcare decisions, the doctors always need to be deferring to me. And we'll get these calls, right? My mother's sick. I would really like her to get treatment. She doesn't want to. Can I make her get treatment? Right? And as long as mom is competent to make the decision that she doesn't want it, she gets to make that decision. So the fact that you're named in this document doesn't override her. It is someone that subs in an opinion if the person can't make a decision for themselves anymore. When we draft a healthcare directive, we usually have several parts to it. So we call that a combined healthcare directive. And some of those parts are there's a living will, which says if I'm at the end of life with no hope of recovery, I don't want extraordinary measures taken. And obviously, it's up to the client. If that's their belief and that's their wish, we include that language. If it's not their opinion and their belief, we don't include that language. Most of my clients do fall in the category of wanting to have that living will in their healthcare directive. I wish it wasn't called a living will because it does confuse people. People confuse the last will and testament with the living will, but they're very different. So the living will essentially says that you don't want artificial means of respiration, and you don't want CPR and those kind of things. We also have a section that says who can talk to your doctor. So it gives HIPAA authority. And that's just, typically it's the same person that's making your decisions, but sometimes people will add someone extra in the HIPAA section. So for instance, my husband's a physician. He has an uncle who included him in the HIPAA section, even though my husband will not be the decision maker. They thought that it would be good to have him included in discussions with their physician. So there's a HIPAA section. There's a section on organ donation that you fill out when you come in to sign. And it says it has a few different ways you can go. So the first question is whether or not you want to be an organ donor. The second question is what you are willing to donate. And the third question is what purposes you're willing to donate for. So for example, if you say no, then that's the end of that. If you say yes, you're willing to donate, you could say I'm willing to donate anything. And you could say I'm willing to donate for any purpose. Sometimes clients will say I'm only willing to donate for purposes of transplant or something like that. So that's part of our healthcare directive. There's also a section that says if I ever needed to have a conservator appointed by a court, and that is a legal proceeding in a probate court, where the court appoints someone to make decisions for you. In that case, it says, you're able to nominate who you would like to be your conservator. The court's not bound by that, but it is you giving voice to something in the future when you might not have a voice. So these documents I think of as very powerful because they allow you to have your feelings expressed and to allow you to have a say in who's going to make decisions someday if you're not able to. And when you think about people in your life, some people might be wonderful people, but not at all be the people you want making these decisions, right? I'm one of 6 kids, and I would think that every one of us might make these decisions a little bit differently. So it's important when my parents choose someone to choose someone that's going to make decisions aligned with their wishes. So these things I think are very powerful. Again, I do suggest this for everyone over 18. My son during COVID hiked the Appalachian Trail from Georgia to Maine, and I wanted this signed before he went away because I was worried. What if he fell in Virginia somewhere and the doctor wouldn't talk to me, right? Wouldn't let me know about his condition. So I like these signed for everyone over 18. So these aren't documents just if you're old or frail or something like that. These are documents that I think everyone should have in place. Let's see. So what can your healthcare representative do? They can make healthcare decisions, and they can accept or refuse treatment on your behalf if you've given them those authorities. And also in your document, you should be telling them what your preferences are so that they know that they're doing the right thing. I had 2 siblings come in once and their parent had passed, and they came in to talk about the estate administration. And one of the siblings turned to the other and said, ultimately I found mom's healthcare wishes. So they had gone through their mother's sickness without the benefit of seeing what her wishes were. And the other said, oh, you did? And they said, yeah, we did what she wanted. And they were so relieved. So two morals of the story, right? One, letting people know what your wishes are lets them off the hook and takes a burden of decision making off them. But 2, if you've made these decisions, it's good to let people know and let people to know where they can find the documents so that they're not left hanging even after you've done the work of making these decisions. The healthcare representative can't make the decisions, like I said, override your decisions, right? You're going to be the person that talks to your doctor. And this is a question we get asked a lot. Is a living will the same thing as a DNR? And they are not the same thing. So the differences are that a DNR says, I imagine it if I were in a car accident on my way home from work today, right? I think of myself as young, and I'm healthy. And if I were in a car accident on my way home from work today and I was unconscious, and I have a living will, which I do, that says if I'm at the end of life with no hope of recovery, don't take extraordinary measures. Someone looked at that, they would say, she's not at the end of life with no hope of recovery, right? She's been in a car accident. There's a good chance she's going to make a recovery. So they would give me, all of the medical treatment to save me and to prolong my life. But if I had a DNR in place, and that would mean that I would be wearing a DNR bracelet, they would look at me and say, you know what? She doesn't want any medical intervention, right? Because she has said she does not want to be resuscitated. So she's unconscious, her heart has stopped. We're going to just let her go. And so it's a very different outcome with a DNR than it is with a living will. And so you want a do not resuscitate order is something you need to do with your doctor or with the hospital staff. And you need to have it posted in your home or have a bracelet on your hand or something like that. So it's a much more dramatic decision because it's saying that I don't want these measures taken in any event, right? So it's much more dramatic and it's much more. I feel like it's a bigger decision, right? Someone has asked a question, should someone other than the spouse be power of attorney? Does a spouse have the same abilities as a power of attorney? And that's a great question. A lot of people do assume that a spouse can make legal, financial, medical, all those kind of decisions just by the nature of being a spouse. This is not true, right? So without the paper that says you are authorized to make these decisions for someone, you do not have the authorization to make these decisions for someone. Legal, financial, any of it. You try, if there's an account in your spouse's name at the bank, try to go into the bank and take money out of that account without your spouse. And you will see that they do not care that you are a spouse. That account is in that person's name. And it must be that person or someone they have authorized. So the spouse does not have these authorizations. And whether or not it should be someone other than a spouse, that's really, that's up to you. Most people that I work with do choose a spouse, but not all. Some might choose a sister or a brother or a child or something like that. One of my favorite stories is of a couple that had come in and they'd been married many years, like 50 years. And they did not choose each other as agents under the healthcare. And the wife said she was sure the husband would snuff her out. And I thought that was funny at the time, but it just showed they had different ideas about end of life. She wanted kind of all measures taken, every chance, tracked down. And she knew that he was someone who didn't believe in that. He was someone that kind of was like, well, if it's my time to go, it's my time to go. So she did not want him making her decisions. She chose their daughter. He chose their son. So they each made a different choice. And sometimes I'll see that, right? But so it really depends on the relationship. It depends on people's ideas. It depends on people's, ethics and all of that stuff. So that's a great question. Here's just a little chart on the difference between a DNR and a living will, right? So the DNR, as I mentioned, has to be put in place by a doctor or a medical professional. Probably could be an APRN or something like that. It only relates to these life-saving things like CPR. I think when maybe, so anything that kind of like a crisis, right? Do we want to let the person go? And then it's something that you can provide to your physician, whereas a living will covers all kinds of things, right? You can be as specific as you want, but breathing tubes, CPR, nutrition, hydration, those things that at the end of life are just keeping you alive. And it does act as your voice when you're not able to voice what your wishes are anymore. All right. So I didn't get any notes from anyone that had a power of attorney or healthcare directive in place. So that's one thing. How about a will? Does anyone have a last will and testament in place? I would love to just kind of take in a poll here. So the will is the document that I think people think of when they imagine opening an encyclopedia to the words estate planning. They imagine seeing, a last will and testament in that. That is what determines where assets go at the end of your life if they don't have their own rule book attached. So what do I mean by that? So if I have an account at the bank, so we'll go back to my bank account, it's in my name, Colleen Masse's checking account, right? And I die someday, someone's go to the bank and it just says Colleen Masse's bank account. The bank doesn't know what to do with this, right? So because there's no mechanism in the checking account doesn't say anywhere where it goes. The probate court takes control of how that gets distributed. If I have a bank account and it's in my name and my husband's name, well, the bank's going to give that to my husband. If I have a bank account and it says what's called a transfer on death, that says upon my death, this goes to my husband. Well, the bank knows what to do with that. It says to transfer it on death to my husband. So when there's an asset, like a bank account or a house, if I owned a house and it was just in my name, Colleen Masse's house, when I die someday, someone looks at this house, they look at the deed, it doesn't say what to do with it. It just says that it's my house. Well, I'm not here anymore. So in those situations, the probate court is going to be in charge. And the probate court will look to your will if you have one. So if I have a will, it's going to say, oh, I want to give my house to my 2 sons. I want to give my house to my husband. I want to give my house to my cousin, right? So it's in my will. The probate court says, good, she told us what to do with this. If I don't have a will, then the probate court has its own order, right? It can go to, it depends on what you have. I usually keep it somewhere, my probate list. And it's like, if you die with a spouse, but no children, if you die with a spouse, but no husband, no parents, just looking to see if I can find it to read it off for you, but I don't like spotting it right off the top of my head. So it says, it's called the intestacy statute. And for instance, if I die with a spouse and parents in Connecticut, my spouse gets the first $100,000. After that, it goes 50% to my spouse, 50% to my parents. Okay? So that's interesting. Wouldn't expect that to be the case. So there are different things like that where the intestacy statute will say where things go if you haven't said it in your will. And so I do suggest that people want to have a will in place because you don't want the intestacy statute to be making these decisions for you, particularly in situations where you may have a partner you're not married to and you want to make sure they get something. They're listed nowhere in the intestacy statute, particularly in the situation where you might have stepchildren. They're not included in the intestacy statute. So a lot of these situations, when you have a blended family, right? You want to leave something, you have a second marriage, so you have stepchildren, you have a new husband. What does the intestacy statute say? It may reflect what you want, but it doesn't necessarily. So in all these situations, we want to have a will in place. I see one person's got a will and it's 30 years old. Well, it may or may not still say what you want it to. I have had clients come in and they would show me their estate planning documents, and they'd say, well, this says everything goes to my kids. And I would open it up and I'd say, actually, it doesn't say that, right? It says something different, because back when you did it 30 years ago, your life was different. And you didn't think that it was appropriate to leave to your kids. They were 6 months old. So you were leaving everything at that point to your sister, who you had to deal with that she was going to watch your kids, right? So we want to make sure that if it is that old, we want to make sure it still says what you want it to. The other thing, if it's 30 years old, we want to know, do you have the original document? Do you have the original one that you signed with a pen that in the office, those exact pieces of paper? Not a copy of it, not an email of it, not a fax of it. The probate court wants to see the original document that you signed in your lawyer's office. So you want to make sure that you know where those are. And sometimes we find when someone's will is 30 years old, that during life, they may have moved or something happened and that's gotten misplaced. So that's something too we want to think about with one that's 30 years old. So as I mentioned, if you have no will, you're giving the state of Connecticut the permission through the intestacy statute to make these decisions for you. So what happens? Here we go, right? So dying intestate. Sue and Doug were happily married for 24 years. Doug died suddenly, owning assets in his sole name. They didn't have children. He didn't have a will. Sue was upset to find out that part of Doug's estate was going to his parents. It wasn't all going to her. If he had drafted a will, would he have left everything to her? Probably. We don't know. But because he didn't, it goes according to the intestacy statute. Here are some celebrities, right? When Prince died, he didn't have any estate planning. And, he had $156 million. Well, when you're looking to the intestacy statute, at least if it was in Connecticut, it would be looking, does he have siblings? It would be looking, does he have children? Right? All these things. And as a result, because he did not have an estate plan and didn't have a will, all these people were popping up saying, oh, I'm Sting's child. I'm Sting's brother. Not Sting, Prince's brother, Prince's sister. A friend of mine just went to see Sting last night. So I have him on my mind. But, because there was no will, all these people thought it was fair game to try to make a claim on his estate, because then they would be included in the intestacy statute. Sonny Bono, there was a whole mess with that. His wife, Mary, there was no estate. There was no executor in place. If you don't have an executor and the court is appointing someone to manage your estate, that person's called an administrator. So Mary jumped in, she became administrator, and then there was they had to decide, what does Mary get? What do the kids get, right? Because he didn't ever say. So these are things that I think are very powerful, right? We want to be able to decide for ourselves. Who's going to make decisions if I can't make decisions? Who's going to have my things if I'm gone? And it gives you power to be able to have your voice heard at times when otherwise you're not able to have your voice heard. Another aspect of an estate plan, which isn't something that people think about much, are beneficiary designations. So when I was mentioning what is controlled by a will, right? What is controlled by that probate court? I said it's something that is in my name with no direction, right? No instruction manual for when I die. And things that do have an instruction manual are things that have joint ownership, things that have transfer on death, also things with beneficiary designations. They have an instruction manual. So my life insurance says, someday when I die, I'm leaving everything to my husband. So when you look at the life insurance, it says on it what happens when I die. So that doesn't have to go. The probate court doesn't have to get involved in that. It's got an instruction manual. It also says that if my husband's gone before me, everything goes to my two sons. Again, no instruction manual needed. I mean, the instruction manual is there, no probate court needed. If by some awful situation, my husband, my sons, and I were all to die in a common incident, And all my life insurance says to my husband and then my kids, well, now you've got a life insurance policy and the instruction manual is no good anymore, right? Because now the people that it said to give it out to aren't here. So now we're back to that point where we have no instruction manual. And at that point, it would look to either a will or an intestacy statute. But as long as your beneficiary designations are comprehensive and up to date, those assets fall outside of probate. And the probate court does not take custody of them and does not take control of them. So those are super important. And a lot of my clients, when I look at what their assets are, their biggest assets are their IRA or their life insurance. So most of their assets are going to pass outside of probate anyway and outside of the will. So it's something to be very careful, because if you set everything up and it was all going to your husband, right? Or let's say it was all going to your boyfriend, right? You set everything up, it's all going to my boyfriend. We've been together for 20 years. My life insurance, my IRAs, everything's going to my boyfriend. And then you break up and you come into my office and you say, you know what? We broke up. I want to change my will so I'm no longer leaving everything to Joe. Okay, we can change your will. So your will says everything is now going to your kids. We can change your power of attorney that says now your agent is your sister. We can change your healthcare directive to say now the person to make medical decisions is your brother. We've changed all your documents. We've wrapped it all up. We had a good, relationship. We got things signed. You went on your way. But if you didn't change your beneficiary designations, then someday when you pass away, even though your will says everything's going to your son, your beneficiary designations still say everything's going to Joe. And so your life insurance, your IRA, all of those things are still going to Joe. So when you update your documents, we are very conscious of this. We want to make sure that your beneficiary designations are up to date and they still say what you want them to say, because that's a big deal. Because that does not go, the probate court doesn't look at it. The probate court doesn't oversee it. It goes to the person named. So you need to be very careful with your beneficiary designations. Have any of you ever requested copies of your beneficiary designations to review them? Love to know if anybody's looking at their beneficiary designations. We just had enrollment here for next year's benefits. So I did double check my 401k and make sure that it had my husband and then 50% to each of my kids. So I don't have a third level, but having my husband and then the kids is, so I just double check it every year when it comes around, because sometimes what'll happen is they'll say, oh, we're moving your IRAs from Fidelity to Charles Schwab. And somehow when they make the move, your beneficiary designations don't get carried over. And we see it all the time because we do estate administration. So people come in, they're like, oh, my mother had beneficiaries on everything. And we look and we say, it never got transferred over. So now we have a whole probate estate to deal with. So something to be careful of. A will versus a trust. What does a trust do? So the reason there's what are called living trusts, which means you set it up while you're alive, right? The one we're going to talk about today is a revocable living trust, and that's what you would most likely hear about when you're listening to a financial advisor or something talk about a trust. And we use a living trust for a variety of reasons, but typically a living trust acts almost like a will. You still want the will, because anything that doesn't have directions on it needs to go through your will, but you can move some of your assets into a trust, or you can change some of your beneficiary designations to the trust. So it's helpful in those ways. And we use it for a variety of things. So 2 important reasons we would use a trust like this is if you have real estate out of state, or if you have a family with conflict. I can never tell if those people are siblings or if they're spouses, or I don't know who those people are with their backs to each other, but they certainly don't seem very happy. Right. So if you have land outside of Connecticut, right? Maybe you have a house in Connecticut and you have a house on Cape Cod, right? We can all dream. When you would pass away someday, the house in Cape Cod is going to have to go through probate in Massachusetts, and the house in Connecticut is going to go through probate in Connecticut. So you have 2 probate estates. That's a lot of work. If both of these houses are owned by a trust, because trusts don't die, even though the person that set up the trust might die, the trust can still hold on to that property and it can avoid most of the probate process. There's still a form that has to be filled out with the court, and probably in Massachusetts and Connecticut, but it's a much quicker and easier process. As far as family with conflict, when someone dies, that will that says everything to my husband and everything to my 2 kids is in probate court, and anyone can review that. Anyone can read it. Anyone can go to the court and ask to see what the will says. But if my will just says I'm leaving everything to my trust, and in my trust is where I have kind of the nitty gritty, I may be leaving something to this one and not to that one, and I'm leaving more to this one and less to that one. That is all private in a trust. It makes it there's less of a possibility for if you're not having a full probate estate, and we're not going to get into all of that today, then your heirs don't all have to be notified, right? So that's very helpful. So they're not all getting notified about the will. They're not all getting, notices about hearings and things like that. But your trust can keep things insulated and private and help to carry out your wishes. So those are some of the reasons we really like a revocable living trust. It keeps things out of probate because everything has an instruction manual, right? It's not left without an instruction manual. It's got one. And my trust now says everything to my husband. And if my husband's gone before me, then everything to my 2 kids. So the instruction manual can be in the trust instead of in the will. So what we're always looking for is to make sure things have an instruction manual so that the court and so that so the probate court doesn't have to get involved, right? So that's, a good way to be thinking about it, I think. You want to use a lawyer that does estate planning. I think that's very helpful. I had a client that brought in some documents, and I was a little bit confused by the documents. I was like, these don't seem typical. It's not the way I would usually do it. So it's not the way. And I always, brought up in a good Irish Catholic house. I always assume that it means I don't know something. So I looked up the other lawyer and I found that it was somebody who mostly does criminal law that had drafted the documents. I was like, so, it wasn't somebody that specializes in this. So as a result, I think that they probably didn't know really how to do things. So I actually am reaching out to that attorney to just double check. Did you know how to do this? Did you do this for a reason? Am I missing something? I always give the benefit of the doubt, but you want to make sure that the person you're using is someone that's done this before and that specializes in it. Someone has a question. If you plan to move out of state in a few years, should you wait to set up a trust until you're in a new home? So it's really a judgment call, right? If you don't have things in place and something happens to you in the meantime, then you didn't get the advantage of having the documents in place, right? Trusts and wills are what are called, they're given full respect in other states. So if you've drafted your trust or your will and you've drafted it in accordance with the rules and the laws of the state where you drafted it, then it should be accepted and honored in your new state. So I think it probably depends on a lot of things, where you are in your life, how healthy you are, how certain you are that you're going to move, all of those things. Because the longer you put things off, obviously we know that things tend to stretch longer than you expect them to. So here's the situation, right? Prepared his own will, didn't have the correct number of witnesses. Court wouldn't admit the will. We see this a lot with people that are doing their own documents online. is that they might not understand the signing requirements. And as I mentioned, to be respected in Connecticut, or if you've moved out of state, it has to be executed in accordance with the laws of the state where you executed it. So if it's not executed properly, then it's not going to be accepted by our court or by anyone else's court. I have a client who just who sent me an unsigned will. My mother, I don't have the sign. I can't find the signed one. I just have this unsigned will. So if you have an unsigned will, you have nothing, right? You might as well be a blank piece of paper. So it doesn't, the court's not going to look at it and won't consider it. So same thing with something that doesn't have the appropriate witnesses. Lisa Marie Presley, there were all kinds of crazy things going on in her stuff. Things were misspelled. They gave a lot of question as to whether or not the amendments and the codicils were even drafted by, were signed by her. The signature was odd. So it became an issue with her estate. And, it dragged out for quite a long time. I never quite understand why these people that have all this wealth, I mean, I can understand if you're like a normal person, you're working 40 hours a week and you're very busy and you don't have a lot of money. I can understand why sometimes people are like, oh, I want to go have an estate plan drafted up, right? Do I have the time? Do I have the money? Do I have the patience? But these people with these fortunes, I never understand why they don't, right? I mean, clearly it would make everything so much easier for the people they leave behind. And what a legacy to leave behind a mess like this. What do you do with your documents once you've got them signed? So some clients have a great safe place at home that they want them, and they say they're going to take the documents home with them and keep them, and they have a safe place, and they'll tell me where that is. I put it in my notes. I've had people say, I'm going to put it in my safe in my basement. They'll give me the combination. I have it in my notes. So someday when something happens, the kids call, I can say it's in the basement. Here's the combination, right? Some clients will leave their will with us, the original will. Because remember, I said that original will with that you signed in my office, that exact piece of paper needs to go to court. So some people will leave us the will. We keep it in a fire retardant cabinet, and they get a copy of the will for their safekeeping, and it's got a big stamp on it. It says the original is at Czepiga, Daly, Pope and Perri. So that's an option. Safe deposit box, as I already told you, get me very concerned. I had one client and she said, oh, my husband left his will in the safe deposit box. And I said, okay, where is it? She said, I don't know. It's at a Webster bank, but there are 5 of them right near me. Okay. So she called all the Webster banks. She finally found the one. She said, he told me my name's on it. So she goes to the bank. They say, your name's not on it. So then we have to go to probate court. Probate court. The will is in the a safe deposit box, and the client's the executor. Well, how can you prove to me the client's the executor if the will's in the safe deposit box? So that goes through a whole process. Then we get authorization from the court to go get the will out of the safe deposit box. So they have to drill the safe deposit box, get us the will out. Here's the will, fine. Person there that day said, oh, you know what? Your name's been on the back of this card the whole time. You could have come at any point and opened it. So even though her husband had done it right and had her name on the card, the people at the bank told her the wrong thing and caused all that work. So we are very reluctant about having documents in a safe deposit box. Make sure, if that's what you're doing, that your kids are listed, that your grandkids are listed, that everybody's listed, that they can get those documents out, because they are a hassle. But you want to keep it safe, particularly the will, because that will, like I said, I've said that probably 6 times already, needs to go to probate court. Flojo never found her will, and it took the court 4 years to close her case, right? People start arguing, people start fighting. It's not a great situation. So we're about 45 minutes in. I'm happy to answer some more questions. If people do have questions they want to email me, my contact information is here as well. And, I'm happy to answer general questions. As I mentioned, I can't answer personal questions or specific questions to non-clients. But I'm happy to hang out for a few minutes now and answer any questions if anyone has any. All right. Doesn't seem like there's a lot of questions, so I'm going to put myself on. I'm going to turn off my video and put myself on mute, but I will hang out here in the chat for a little bit. If anyone does think of anything they'd like to ask, I will be here and for a couple of minutes. And hope everyone's having a lovely day. It looks sunny out there, and happy holidays to you guys. Someone did ask about the different kinds of trusts. We actually have a whole presentation on this. So if you want to go on our website or sign up with our marketing department for when we give that one. So there are irrevocable trusts that people use for asset protection, basically to protect against the costs of long-term care. There are special needs trusts that we use for people that have disabilities that may be needing benefits in the future. There are, living trusts, which can have all kinds of bells and whistles in them. There are pet trusts, which sometimes people will set up to provide for a pet over the long term. But by far the most common one that people use are the revocable living trusts. And then next to that, I would say in our firm, we see a lot of the Medicaid protection, asset protection trusts. But we do have a whole hour that we spend talking about different kinds of trusts. So you can either email me or you can email our marketing person, whose email is just like mine, except the first word is Jill at ctseniorlaw.com. And she can, have you on the mailing list in case, you want to attend any of those other presentations.
All right, if we don't have any more questions, we can wrap up for today. Thank you for joining us, and thank you, Colleen, for the presentation.
Thanks so much. Have a great day, everybody.